All right, Judge, we're ready to go ahead and get started. We do have a quorum and I can read off to you who's online.
If you don't mind.
Sure, we've got John Warren, Aaron Varner, Blunta Alamia, Chris Ricci from Tyler, Cynthia Orr, Todd Smith, David Escamilla, Dina Williamson, Diana Parsons, Doug Gowan, Jamie Gillespie, also from Tyler, Jess Griffith, Justice Boyd, Judge Ferguson, Justice Doss, Mark Unger, Mike Caro, and Patty Henry. And then we've got Roland Johnson, Jay Sanders, Shay Stroik, and Stephen Stelling, also from Tyler. And we do have a quorum.
Perfect. All right, so thank you all for being here. We, particularly after we've kind of had to change the meeting dates and that sort of thing, we really appreciate you attending. We're going to go ahead and get started, and we'll start with the meeting minutes from the February 24th meeting. I hope you've had an opportunity to look at those and make sure that if you were in attendance, that you are shown on attendance, because we do take note of that. So do I hear a motion on the minutes to approve the minutes? A motion. Okay, so I have a motion. And a second. So the minutes for the February 24th meeting have been approved. First, we're going to go into program updates from Tyler. And so we have a representative here.
We do, and he's going to.
We're going to see our normal PowerPoint. Kind of, maybe.
Very good.
Sorry, I'll start. Okay, for those who haven't met me yet, my name is Evan Acosta. I'm the Guest Texas Program Director, helping oversee the new functionality rollout. So, we'll start with our typical kind of just met our typical filing volume metric. So right now we just went over the over 800,000 user accounts created today, still averaging about 47,000 filings a day. $1.3 million goes through the system on a daily basis. And then we hover around between 79 and 80% typically around the state provided filing portal volume every day.
Okay, so Evan, I'm going to ask you just to speak up a little bit, just so that, to make sure everybody on the Zoom can hear you.
Okay, so I actually did refresh the JP numbers a little bit. They felt a little low. We actually have 230 precincts live across 55 counties and 21 out of the top 22 counties live. I think the last one was Hidalgo, had a JP4 went live, and right now we have 4 active/pending JP engagements.
So Evan, how do they engage you? In other words, so some of the counties will have a couple of the JPs that are maybe on, and then the other ones aren't, or is it more likely if one in a county comes, they all come?
Yes, and short answer is yes. We've seen all kinds. Typically when we have one JP, the others just like, hey, let's just get you guys all done at one shot. But the way we set up the configuration, the way we rolled out, easy when other JPs want to come aboard, because typically their configuration on the CMS side doesn't vary too wildly. So you can kind of set it up for one, flows down also when the next JPs come aboard, which typically they all kind of trickle on once they see the benefits. It's just a matter of getting bank account stuff set up and just plug them into the system.
Okay.
Any questions?
They're not clicking.
Uh-oh.
They're trying. There you go.
There. Okay, so the return for correction rates still hovering around 6.5% return for correction rate on the average. We see a slight trend up in April, but we usually see that whenever the filing volume really starts to pick up from the new year, January, February, March, those as the kind of the high volume season leading into summer.
How does that compare nationally?
Right over here, you guys are about a whole percent point lower than the national average, but Texas is also a much more mature system than some of the other accounts that are coming online. So breaking that down a little bit further, so we tweaked this slide a little bit based on feedback from the last meeting, so to kind of talk through it again, on the left side, we have county and district courts. The case type itself that or the top 10 case types by return rate, the caveat there is that we actually aren't pulling in the raw return filing numbers. So there's a couple different ways you can kind of think about this slide or how we want to take it moving forward. Is do we want to look at sort of the raw numbers of return filings and kind of examine that? Or do we want to look at, okay, what is the actual return rate on a particular case type? So what's sort of the impact we want to look at there? So this is sort of the next iteration of that information. So again, the return filings here, the percentage the return rate percentage for that particular case type. And then one of the newer additions is what percentage of that particular case category the case type is in, what percentage of filings that make up of the case category. So
like, for example, when you've got here divorce with children, that's part of family.
Marriage relationship.
Marriage relationship. And so out of the marriage and relationship case category, divorce with kids makes up 68.3% of the cases.
That's correct.
And then of that 68%, we see 8.73 return is our percentage return rate, which amounts to 34,000 filings.
That's correct.
So the 68% return rate is for the category of just marital.
It's just saying that divorce with children makes up 68% of the family marital relations overarching category. Because in that category is also divorce, no children, annulment, those kinds of things.
Okay. Oh, that's it. Yeah.
And so I think, to me, I would, and Evan, correct me if I'm wrong, I would take that percent of category as an indicator, because if it's a high number, like debt collection is, that means that the vast majority of civil, whatever that big category is that this is under, that debt collection is one of the larger players within that category versus where, like, you see debt contract other, that's going to be in the same category, but it only comprises 12% of the major category. And so to me, if you see like independent administration, the return rate's at 11.7%, and it's almost half of the category, that to me would be, we should focus on that, because that's a bigger chunk of a bigger chunk.
Yes.
Correct. So kind of a different way to view what's the impact of the return rate for these case types.
You know, you might put a, I don't know, footnote or something, or color coded or something to know, because you have percentage of category, but what categories are they? You don't know what's in the
I had the
category.
category there too, but it made the things.
Made it too big. I just want to color code like the divorce with children, divorce without children, like those can be, I don't know, somehow, so that percentage of category makes sense.
It'd be pretty easy to break this on different slides and be able to put that information in there.
Okay. Thank
And
you.
Mark, you had your hand raised.
Yeah.
Yes, sir. A quick question. Do we measure suits affecting the parent-child relationship, which would be suits with children that are not, there's no marriage attached to it? And is there a breakout from OAG cases versus privately filed cases?
So we do have those OAG cases are in a different case category, so we do measure those separately. And apparently, based on the top 10 case types, none of those come up.
That's correct.
In the top 10.
But there's
non-OAG cases that are SAPSers. In other words, not OAG
Oh,
filed.
you mean non-OAG cases that are
That are
separate?
suits affecting the parent-child relationship. So it doesn't necessarily involve a divorce or something like that, but it does involve a
Yes. So
modification maybe, or something about it.
So it depends on how that case is essentially categorized in the system. So if they file it with that specific case type, yes, we do track it.
Okay.
So there's parent-child relationship cases, there's motion for enforcement cases.
I see.
So parentage cases. So it just, those cases just didn't make it, basically they didn't,
make it into the top
make it in
10.
the top
I
10.
see.
But if there is, like, again, if there's specific interest in certain case types, especially sensitive ones, whether they're in the top 10 or not, if we just want to track kind of the health of those, we can easily pull those in as well.
Thank you.
And then on the right side is the same thing, but with the JP courts, and it's pretty top heavy. Obviously, some of the debt collection, evictions, and the small claims, debt claims cases make up a large portion of the filing volume, and then it kind of, yeah, you can see sort of falls off a cliff when it gets the occupational license. And
In large counties like Harris County, the number one is debt collection.
yeah,
Number two is evictions, number three is small claims. So that sounds right.
right on mark.
And the small claims, covers a wide band of kinds of cases.
It's pretty,
So the potential for them to have defaults in the information they're providing is small, and there's still a fair number who are filing, who are not e-filing.
Yes.
Yeah. One thing we could do, thinking about that is, because I'm willing to bet because there's such broad categories, I would have ventured guess at probably the return for correction reason on that, maybe wrong case type. What you're filing is not correct for what you actually need to submit. So we could, if we split this on two different slides, add in a category, and then you could even put a little something in there that says, hey, what are some of the top reasons for these particular case types that are very impactful and have a high return rate?
Yeah.
Or they file against an entity that can't be served. We had cases where people file against a phone number. How do you file? How do
I
you
see.
serve that?
Mm-hmm. Okay.
Any more questions on this slide? Or we want to move on to the,
I think we can move on.
okay. So could you click, sorry, you're okay.
Okay.
One side comment, debt collections, because the credit cards are going up.
Yeah.
Fairly fast.
Yeah, the CPI report came in about flat this week, but.
Okay.
There was actually 46 interviews live where the previous was 45. I had a chance to talk with some of our OGF team because I believe one of the last questions we had was, why aren't more interviews integrated? So one of the answers there was, or there's two big problems that they had mentioned, is that one, that there's just so many variations from county to county on the process, whether it requires to be notarized with a certain fee, certain filings. It's not uniform enough to really integrate seamlessly across the state. Basically, each county would have a pretty intense kind of implementation process, or they require outright tweaks to some of the interviews.
Okay, and are these the interviews that we're talking about, the forms that the Supreme Court has approved? Is that what we're?
I believe so. And then,
Okay, so they've been approved by the Supreme Court, but other counties have started glomming on their own processes or additions or whatever to those approved forms.
correct. And then the other one is that some of the forms, the way they were built and the way the questions evolved weren't, they don't lend themselves to being e-filed very easily. So kind of an extension of the previous reason. So that's a big, it's a big reason why we don't have more interviews integrated.
Well, I can't remember what, I think we were looking at getting a group together to talk about the extra glommed on stuff. 'Cause
Yeah, we need to,
that's
because
stuff
this
that
is,
you can't glom on.
right. So we need to really kind of set up a group to talk about, because that's going to be rendered useless for our access to justice. Because we purport to say, if you fill out this form, you'll be able to file this case and you'll be able to move forward. But instead, they do it and they get it back. And then I don't know how many of them like give up then or what they do. But we need to kind of analyze and figure out how to most efficiently allow them to use the forms that are provided that we said were approved and get them through the system and work with those counties too, because I'm sure they have reasons why they're counting on it, but we need to figure it out.
Right.
So I don't know which word gets that, but I think so too.
So just a little bit more, the completion rates so far in 2024 is about flat with 2023. We actually saw a small dip in the last couple months that it was trending towards 36%, dropped to 35%, not 100% why. it dropped a little bit, had to do a little bit more.
Well, if you're not successful, I mean, that's what really bothers me. If you're not successful in filing, you're never gonna grow that. I
Right.
mean, if this percentage isn't gonna make it through the system. Anyway, okay.
And no surprise at the top counties that have, OGF, completions. So obviously they're part of our top 10 most populous counties.
Yeah.
And then just a little bit more of a breakout on the, sessions completed on print, what are printed and, maybe brought into the court or what were actually e-filed into the system.
Okay, and then do we have a list of the counties that are struggling with getting these things completed? I see that we have like Tarrant and Harris, Travis, Dallas, Collin, but I'd be interested in like,
You can look at that, like,
yeah,
what have the lowest percentage?
Yeah,
What
what
has the
have the
highest percentage of
lowest-
starts
yeah.
and the lowest percentage of
Yeah.
completions?
yeah.
And then a quick research update. So I modified the slide a little bit. There used to be the feedback from the legal professionals up there around, criminal data, hearings and
Mhm.
whatnot. So we know the answer to a lot of those are coming. So for the interest of refreshing the slide a little bit, I pulled in the document purchase revenue for 2024. And I believe this is a Mark Unger question from last time was out of that document purchase revenue, what counties are basically making up the biggest portions of that? So I pulled in the top 10 counties by the revenue generated by document purchase.
And so that is from January 1 to today, correct?
Correct.
So see, look at that, Bear County, $18,000.
So what does that tell you about the system they have for these? Wildly. immediately
Well,
went
that's one way to
research
drive
Texas.
adoption.
Yeah, no, I love it. I'm glad.
And nothing new to report in terms of the court's integration status, still hovering around 10% integration. We obviously, with the looming mandate, we're having a lot of interest from counties that kind of know it's coming, see the writing on the wall. So we're starting to kind of create the procession
Okay.
of who's going to be going when.
This is so far in 2024 through what day would you say?
May 1st.
And John, you have a question?
Yes, as it relates to these numbers, as it relates to revenue, one of the things that you have to keep in mind is that some of us, particularly with Dallas County, we make our records available online to the public at no charge. So that also would be a driving factor for the volume being lower on that. Well, for Dallas, I'll only speak to Dallas County. So, but
Yeah.
that may be a driving factor for some of the other counties as well, possibly.
Yes, I think you could be right.
Is this revenue generated through purchase on research or through
Yes.
counties?
Through research.
Any other questions?
Keep on trucking, Evan. Well, I mean, looking. Okay, was that it?
That was it.
All right, so then one of the things that we were talking about with integrations, the last JCIT meeting, the standards were approved that allow criminal cases out on research. Have you started to see interest from counties on, hey, let's start running
Yes.
criminal out there?
Yes, so we have an interest from counties that want to start the process. They know it's just criminal metadata. We have others that are asking, hey, we know it's criminal metadata, but we have our portal solution we're trying to sunset. When are documents going to be available? So that's the secondary question. But yes, we do have a growing interest of folks that want to plug in criminal.
All right, and so you had said that overall that there are more there are more counties now that are coming in that want to be integrated because they see that that's probably where we're all going.
Yeah.
That's correct.
Okay.
And then with criminal as well, but I mean, Bob, you want to talk to the point about that Evan mentioned about documents not being.
Yeah, when they say documents, are they limiting the documents, or is it if you can get it over the counter, you can get it through research?
So I think we're going off if there's no criminal documents allowed to.
Right, because that's what the standards are.
Right.
Set at.
Today, but the folks that say we're waiting for integration because we want to get documents there, what documents are they talking? Are they talking about everything?
Probably for criminal, yes. So they're talking about, and they would obviously abide by, probably mirror what they, or would like to mirror what they have said before, to where public available documents are public based on whatever the charge is or the statute. And-
Yeah, so if we can get it from, if we could walk up and get it from the counter,
Right,
we just switch that to research.
correct.
Or add research to the way you could access those documents.
And Cynthia, I see you have your hand raised.
I did because I've run into problems in criminal filings where a lot of the trial jurisdictions cannot accept videos or audio recordings. And so I walk in hard copies, and then because the rules say you can only electronically file, then they try and not make it part of the record, and getting that up to the Court of Criminal Appeals, where we're in that weird space where we're litigating before the Court of Criminal Appeals in the trial court in habeas. And so it's a real mess. The rules are not consistent with the ability of those to accept electronic filings of all the information that's put forward in a case. So I just wanted to, not that that's a topic for today, but I wanted folks to be aware of the problem.
Cynthia, is that in Bear County? Is that in most of your jurisdictions, like Austin, Houston, or I'm not sure.
Well, this happened most recently in, I want to say it was Atascosa County, but some jurisdictions you can file electronic or audio recordings or videos, and in that weird place when you're putting on evidence in pleadings and habeas, and they're enormous. It's something, and it's a big docket of cases. We need to make sure that everyone can do it. And Bear County, the folks are more sophisticated and realize, regardless of what the rules say, they have to make a record. But you don't always get professional, reasonable people to deal with in these jobs that haven't had to deal with habeas before. So they're just, but the rules say you have to electronically file, and when you can't, that's an interesting problem.
And is that, okay, so I just want to make sure, and I'm going to show a little bit of my ignorance because I don't recall. So the rules basically say you have to file electronically. Are these local courts or local rules that are saying you cannot submit video electronically? Are they other rules within the?
It's not a rule. They have no capability of accepting it. So the
Right.
rule says you have to
My
file
understanding right
electronically,
now.
but you can't.
Right. The
because
e-file
you're
Texas.
not physically
right now
capable of doing it.
I see what you're saying.
Now, let me ask this though, Evan, do you know off the top of your head, is that just a configuration item?
It is, but video and other formats won't be able to be pulled up like a review queue or anything like that. So we wouldn't be able to pull up and listen to a file or anything like that. It would
Right,
be
so,
be a pass through.
so you have to think from a procedural point of view, you can't stamp a video as filed. And you
I got it.
can't,
When I walked it in physically on the counter and I got it filed, and then they put it in a storage closet and didn't send it on to the Court of Criminal Appeals. And so it was interesting litigation just about completing the record. But yeah, I couldn't e-file it because they were not physically capable of receiving it that way. And then they said, but the rule says you have to e-file, so this isn't really filed. Because I physically walked it.
So, Cynthia, I would love for you to be part of a committee to really look at this in depth now that we're bringing more criminal on board here in terms of the Research Texas, because we need to come up with a solution for that. Absolutely. And, we have sealed documents, for instance, they're not e-filed, they're part of the record. I'm assuming when they took your video, they probably threw them back where they throw the sealed documents, perhaps, I don't know. But yeah, we need to set something up to take a look at that, but I'd like you very much involved because I think you probably have a lot of experience in that area.
Yes, ma'am. And I know that the federal system, they can't accept some really large files, but they can accept some audio and video. But I'm not sure what their rules say about it, but they certainly do accommodate it and make sure it makes it into the record.
Yeah.
So I think from a technical perspective, we could allow it, then the issue then becomes where do you set the file size limit? Because if the system sends it to Tracy for her shop, she's got to be able to accept it.
Right.
And then the mechanics of that, when it comes into the review queue, you won't be able to see it or hear it. You'd have to accept it on faith that it will make it through.
What's interesting is the Court of Criminal Appeals can accept it electronically, but of course, in the habeas, since it's this weird animal, I have to establish my record. Even though it's before them, I have to do it in the trial court.
Is there ability to check the file to make sure there's no viruses on it before?
That, I would imagine they do. They scan it to make sure that it's not malicious.
Right.
But other than that, I know there's no players built in the reviewer app for you to be able to see it or hear it.
Right.
And I don't think the clerk has to, they just have to make sure
They pass it on.
that what is being filed is the correct case number, there's a
Right.
case that exists in the system that way,
Right.
and then this attorney is filing this evidence. Right, is it, an audio or video is evidence as far as we're concerned in the record.
So if though they go up on appeal and that goes up to the Court of Criminal Appeals or something like that, will it then be playable? Because they've got a player of some
Yes,
kind once
so-
that thing goes up.
So.
In other words, it's not flat and dead and
Right.
just some
Yes.
kind of weird file that's not ever gonna be useful.
Correct. So my understanding would be if we said, let's allow MP4s just as an example, then I know that Tracy has a player that can play that because it's an open standard video file. When it goes up on appeal, they have their
Then they can
appellate
keep it.
clerks, if you will, that prepared the clerk's record. And it travels through a different system that OCA puts together that then puts it in front of the either CCA or one of the appellate courts.
You just have to make sure the jurisdiction, once you allow that, have the ability in their document management,
Right.
case management system
To
to allow.
ingest
type of
that,
document.
yeah.
Yes,
That's typically where the rub comes in.
Yeah.
You know, can the receiving end actually,
and just,
can
Receive
the
that.
infrastructure
Right.
actually handle it is the big one.
Right. And then so,
okay, Cynthia's got her hand up.
go ahead, Cynthia.
The problem with habeas is it's not neat like that. It's not a proceeding in trial court and then going up to appeal to the Court of Criminal Appeals. It's actually a live proceeding in front of the Court of Criminal Appeals. And the Court of Criminal Appeals is using the trial court as a special master to get the evidence to come in. And so if it doesn't get in, it's going in before them, but it's going in the trial court first. It's a very unusual animal. So yeah.
But it's going into it's going into which filing system is it going into? It's going into basically the district clerk's filing system or wherever you are.
Yeah, that's right. You used to file directly in the Court of Criminal Appeals and then they sent it down to the trial court. But now they have you file directly in the trial court because they don't have court reporters. They can't bring the defendant there. It has to happen with all that. And so then if they're just receiving it and not filing it, then they're not getting it in evidence before the Court of Criminal
No,
Appeals.
they can receive it. What we were talking about, Cynthia, is the situation where we can create a standard so that everybody knows, this is kind of that every trial court can accept this type or types of video, audio, whatever, and they receive it and it goes into evidence. What we were saying is they don't have a player to play it, but you don't need them to necessarily play it you need the Court of Criminal Appeals to be able to play it, correct?
Could be, unless the trial court decides to have a hearing, and then it would need to be played in the trial court as well. But
But they could,
They-
right?
they
Because
could
the trial court
receive it.
could have a player.
Assuming
could-
it passed into the system.
they couldn't receive it electronically, so I brought it physically. And then we have this rule that says, well, you can't file anything
Yeah,
physically.
no, I think you can file it electronically, and then when you need to use it,
I
it would
wasn't-
be of a file that's such a nature that it's easy for people to play it, wherever you
was-
might need it to be
They
played.
didn't have the capability for me to electronically file it. They could not accept.
Right, no, that's what we're talking about, creating some kind of standards, rules, or we're trying to figure out how to do a solution. So I just wanted to make sure I understood where you were playing it or who was playing it. So,
Could be both places.
okay. Yeah, both places.
Set up to allow like video transfers.
Yeah, and I mean, our inbound tool that we give to the trial court clerks, they can send video and audio that way too.
Yeah, so Cynthia, we'll go ahead and we'll be setting up a
Sorry
committee, so
for-
we'll be
Sorry
in
for bringing.
contact with you. It's a really great question and a really great issue. Thank you for bringing it up. And so, I think it's something that we need to address, now, actually, and get started on it.
What's the status of AI? It was brought up 2 meetings ago. This committee, I'd like to know where we are now.
I would have to,
It's available. I
Yeah.
mean, if anybody wants to buy it, they can buy it. I know that, OCA is having our directors retreat to talk about funding things into the next biennium. And so my plan is to bring it up there because that's something that we could proceed on.
And okay, remind us, Casey, because I'm trying to figure out the status of AI, and that was AI within the e-filing system, right? And what would be the purpose? What is?
So the
of it?
purpose would be to mimic what Tarrant County has today. So the way Tarrant County does it is, and they still have a human in the loop.
Yeah,
West Palm Beach, I believe, took their humans out of the loop. They're now running lights out for some things. And so it's nothing but the bots that are running the show there. But this would, if we were to expand that somehow statewide to where you could then make bots available to all counties.
I see. Okay, that's what I just want to make sure
Yeah.
what we're talking about. Because I know that for access to justice, they've talked about really going back into some of these guide tools, the
Yeah.
filing guide tools, to try and make them, I think it would behoove them to make them easier for people to complete, and it might be easier to create a few little different pathways for them, so.
Absolutely.
Okay, any other questions for Evan? Hands up.
Nope, you're good.
Okay,
thank you, everybody.
great. Thank you very much. Okay, so does anybody else want to be on this criminal committee that's going to kind of look at audio, video that might need to be filed at the trial court level?
Who's on the committee already?
Cynthia and
Tracy.
Tracy.
At John Warren.
Okay,
Deanna Williamson said she will be on it also.
okay.
Did we do some miles lately?
No, he's hard to
He's
find.
in private practice.
Yeah, so, all right, so I've got Cynthia, Tracy, John Warren, Deanna Williamson
Deanna
on it.
Williamson, yeah.
So we'll kind of start with that, and then, Casey will be in touch to kind of start figuring out what the best kind of, conference call times and stuff like that. Generally, we handle this, and John, you and Tracy have been involved in so many committees with kind of weekly, bi-weekly sorts of phone calls to kind of hammer out the beginning of kind of what's going to go on, because right now it's kind of what are the needs and then how to deal with them. And so different counties may have different ways of approaching it. So, so why don't you be the core group, and then people can, join later on as we move along. So, so look for your email from Tracy and from Casey as well.
All right, next up, we have the Standards Committee.
All right,
Yes. We have, Casey sent out to everybody, what we propose to have adopted is, standard 8.5. This includes a couple of, additional services and some filing types. Are these the JP ones primarily?
Yeah, so oh, now we gotta find it. Hold on, let me find it. On the civil side, I believe we added a filing type, that Jess Griffith asked us to add was for, application no fee as a subsequent filing, that in some cases in JP courts, they're filing applications for things after the case has started and there really isn't a fee to it. So they wanted a differentiator with that. And then the other thing that we changed, was in the additional services. And this was, related to a fingerprinting fee that being separate from the background check fee. And there was a clerk who had asked us to add that in there, and the committee decided to approve that and adopt that.
Yeah, because it has statutory reference,
Right.
much to our surprise.
So
And
the fingerprint fee
Yeah,
is
it is.
separate
Yeah.
from the.
And there's statutory.
Yeah. and those were
That's it.
those are the two changes to the technology standards.
They were adopted by the committee unanimously, and we recommend them to the entire JCIT.
All right, do I hear a motion? Well, actually, coming from the committee with unanimous support,
Some,
yeah, they're moving for it. All right, any discussion regarding this? Okay, all in favor? Aye.
Aye.
Raise your hand,
Aye.
say
Aye.
aye. There you go, okay. Anybody opposed? All right, those standards are passed. I'm gonna ask you, Casey, to update the standards with those.
Yep, and I'll our next step is I'll circulate those to the Supreme Court and CCA, and then
Okay,
they'll discuss and adopt if they so choose.
okay.
And their previous pattern is adopt, so.
All right, anything else standards? I think you all had some other discussions.
yes. We had some very lengthy discussions about documents in criminal cases. And where the committee ended up was recommending that as a start, that we authorize or amend the standards to allow the filing of informations, indictments, judgments, sentences, and orders of dismissal, so that you, within research, have a complete picture of what happened in the criminal case. Sherry Woodkin provided us with a great document that not only for criminal but for civil cases looked at and identified all the restrictions there are regarding security and access. And Casey, Tracy, and a number of the committee members took that, including Sherry, went through our existing standards, and we happy to say that we are in compliance with all of those.
Okay.
But there is this issue, as you heard earlier, about, well, if we can get criminal documents at the counter, why can't we get them through research? But where the committee is now is we adopted,
And that's for counties that are integrated.
and that's for counties that are integrated.
Okay, so do you have a document or anything that lays this out?
We were bringing it here first.
Okay, so I think it's hard to, so I have concerns that I'll express. Okay, so you have documents that are available that some counties put out. We complied with all the restrictions. We're all in agreement that if the legislature and everybody else has statutes and things that restrict the access to certain documents, that clearly we don't make those available on research access. Under what your thoughts were, though, the attorneys of record on a particular case, they would have access to everything that is not statutorily restricted. Is that correct? On
Yes.
Research Texas,
That
the
is
attorneys
correct.
on the case. Okay, So we're not, so that's it. So now we're looking at what would the general public have? And that's where we kind of are not doing what we did in the civil side. On the, we're basically saying that you only get certain classes of documents, is that right? Or what does the public get to see in a criminal case?
Right now, in a criminal case, the standards only allow the public to see the metadata. So the fact that the case exists, what court it's before, case number, style, case
Basically.
type,
Index information.
yeah, case index information,
Okay,
and that's it.
all right. And so is there a recommendation to change that? And do what we do in the civil side, which is documents that are permitted and that courts allow the public to see, some of the counties do, would be allowed on Research Texas.
Right now, the recommendation is the information, indictment, judgment, sentence, and order of dismissal.
And there was a lengthy discussion that it would only be for those counties that are integrated with Research Texas, because then that way they can have the security level of that document in case the charging instrument or something was in a confidential type case or sealed type case, then those would not be available to the public.
Okay.
If they were integrated.
Right. Because they would have already put the security level high enough that is not approved. Okay, so are there counties out there, and I think there are, that do allow the public, either for a fee or whatever, to access all the criminal stuff that is not statutorily prohibited?
We have criminal documents out on our website.
Right,
That are public documents.
that are the public documents that are more than what you're now recommending.
Yes.
All right, so I'm trying to understand why we wouldn't provide that more robust access if other counties, and I don't think you're the only one based on kind of what I've looked at, why you wouldn't provide more to the public.
In an e-filing world, if you take whatever's e-filed and then bring it up on Research Texas, you don't know the security of that document from an e-filing perspective.
Right,
But if that county is integrated with Research Texas, that county is telling you this document is either public, confidential, or sealed.
mm-hmm.
And so then you would know, Research Texas would then have the ability to know which documents to show.
Okay.
in criminal cases.
So for integrated counties that are integrated
Yeah,
and have all that security, those security levels set up, implemented, verified, or what have you,
mm-hmm.
why wouldn't we open it up instead of restricting it?
Right, I guess that's my question. I understand, that makes total sense to me that you want to make sure that Research Texas can read the security
Right.
level of a document before it's up there. But I mean, when people file pleadings, so if I'm a lawyer and I'm filing a pleading, okay, in Harris County, I might put sealed, or I might put some confidentially on there, or is that some
Or
sort of
data
status?
For
Or
data sensitive.
Data sensitive or
Right.
something like that, sensitive data. And so that would flow through and remain in your CMS so that if it's pulled out, it knows the security level, right? But for counties or even small counties, Research Texas knows not to put anything marked data sensitive right? So
It just comes into play, the confidentiality matters like for, functions and or sexual assault, things like that. Like
but aren't those
even-
statutorily prohibited from being provided to the public?
Not all of the sexual assault cases are. Like,
Okay.
even though it's a public document in our case management system,
Mhm.
we say we're not displaying this to the public because of the nature of the case,
Right,
right? And then on some cases, like if a warrant is filed or, the case is filed, there's statutory for federal, felony indictments and those sort of things. You have to keep that confidential until the defendant is arrested or booked.
yeah. Okay,
Same sort of thing for our 2B cases that get filed. If we wait 48 hours before we show that case in our website, because we give the safety of the law enforcement and keep those officers safe while they go out, pick the defendant up, and that sort of thing. So there's different kind of things that we do to protect some of our documents and cases in our system. So
right,
even though they're public, they're not seen on the website.
right. Okay, so here's the issue I have though for uniformity purposes. I'm a lawyer, I practice across the state. I want to be able to rely on the fact that statute doesn't prohibit it. It's required to be, provided to me if I need it, and that's not my case, but I want to go look at it. When we say, oh, they could walk in, where do they walk in to get access to the document that they're entitled to? Where does that
So we
happen?
have a customer service department in our county that they can go and get documents. Of course, they have to be public. If they are the confidential ones in nature, we usually ask for the driver's license and
Right.
make sure they're the party in the suit before we give that.
Well, but if they're not the party in the suit, the documents that by law they're entitled to, right? Remember, they are entitled to know what's going on at the courthouse, and that is cases on that right start in the criminal law cases. So I'm just trying to make sure counties, I am concerned, have no right actually to designate things confidential that are not by statute or by law somehow confidential. We have agreed on the matrix on the civil side, certainly with Harris County, on certain practical reasons why we got to wait 48 hours or why something, and we incorporated those into the matrix because those made sense. Yeah, and uniformly made sense across the board. I'm concerned with if counties can just decide what they want to do and what their policy will be, irrespective of what statutes and the law is, you're going to have inconsistent, which is what we want to avoid at all costs. If you're going to make Research Texas usable, it's got to be consistent so that the lawyer can rely on the data received, that this is all there is and this is what's there. So I'm just a little concerned if we're going to go down a road where data is kind of picked and chosen, irregardless of what statutes and things say the public can have.
And so,
Anyway, that's just my concern.
Judge, we have hands up online. First,
Okay.
we got Mark. Go ahead, Mark.
Yeah, this may be a dumb question, but I wanted to go ahead and put myself out there anyway. Is it possible that some of these documents could be resold by us in contract with anyone else, or by Tyler in contract with anyone else, such that if something criminal was posted and it was later, there was an expunction, it would be like once out, always out, and on the net forever. And I do think that there's a difference, going back to some of our discussions during COVID on access to the courts as a justification for broadcasting everything, which we've now pulled back from, and, private facts, private details, especially in sensitive matters, not defined by 21C or anything else, just in general. And I think some of those sensitivity issues we just haven't fully addressed. But my main question and concern is it possible that they can get out once the criminal documents can get out? And if they do get out, then you can't, issue orders to private entities to seal them up out on the internet somewhere. That's not possible.
So I do know that with the way security works in research, especially if you're integrated, that if Tracy were to expunge or otherwise restrict a record, then if it hadn't been previously restricted, she can go in and see, here are the people who have downloaded this record. And then from that point forward, once that record is sealed, expunged, whatever, secured, then it's no longer available on research. So I agree that once it's out there, it's out there. And research can say, here are the people who downloaded this record. But you're right, if you had bought that record and then 2 weeks from now it gets sealed, research isn't isn't gonna send you an email to say, hey, Mark, that record you bought is now sealed. You're not allowed to see it anymore, kind of thing. Tyler is in their contract with us, they're not allowed to like resell any documents that are on research beyond the purposes that are already expressly done.
So it'd be like Pacer, and I've had situations where, you know, some lawyers maybe filed stuff and didn't mark the exhibit confidential or didn't mark anything correctly. And all of a sudden in their patent case or intellectual property, stuff is out there. Now they immediately will take it down, but it was on Pacer. And so it was there. And if someone had it then they have it. But you know, that's just the nature of the beast across the board. Same thing in civil.
The next hand that we have up is Dina.
So I certainly can't speak as to the judge's thoughts at the Court of Criminal Appeals, but in conversations we've had, the discussion that was just had is a lot of their concerns is that while yes, everything is public information, it's a whole lot easier for someone to sit at their computer and type in a name and download documents and disseminate them, as opposed to getting in their car, driving down to the courthouse, getting the copies. So there is that extra step that is something that they're constantly thinking about when it comes to the criminal cases. And also, like you said, while yes, all these provisions are in place that the attorneys are supposed to mark things confidential and sensitive and sealed, in our clerk's office, and I can imagine we get just a small percentage of what the district courts see, a significant portion of that time, the documents are not filed correctly. And so there's victims' names, licenses, dates of birth, you know, all these things that are supposed to be redacted that the attorneys just file, and we find out after the fact. And so that's another part of the conversation that when this comes up for the judges, they think about as well. So I just wanted to give that information so y'all know where the judges at the CCA stand when they come to these conversations.
Thank you, Dina. It's always appreciated. John, you're next on the list.
I just wanted to echo my agreement with Justice Simmons. We need consistency because even among my criminal court judges, their opinions vary. So in Dallas, we will have one court using one process, and across the hall, another judge using another process. So we do need that consistency.
Agreed. Cynthia?
I just wanted to point out in response to my colleague's observation about how important it is to make sure that our legal processes do reflect what we're hoping to do, like expunctions. There's always going to be information that gets out in the public about criminal cases. For news media, for example, we're in a whole different age, and expunction can't solve all problems. It can only solve the problems over which we have control. I don't think that's a reason, and should not be a reason, to somehow then start treating, deciding that we're going to create new categories of private information. The public proceedings are so important, especially in criminal cases, because that's how we make sure we have public trials, and it is a check on the system, and daylight helps make everything better. So I just don't want us to start trying solving problems that is outside of our ability or that we should control.
Anybody else have any thoughts on this? I mean, it's an important issue.
I do.
Yes.
One of the concerns I have on the criminal side is if there's a judgment, but it's not satisfied, a capias pro fine has been issued. If that information becomes a matter of public information, it could thwart the collections process, which is also statutory. So I want to be careful that we're not releasing information that allows people to go out there and research, find out there's a capias pro fine, and then they go into hiding. Collections to find those people anyway.
I get that.
Yeah.
But I also know that just about every JP court for decades has sold all their, going back to putting them on CDs.
Yeah.
For people to come by and
pick
buy the
up, yeah,
CD
find out.
of everything that's been filed, everything that's been disposed, everything that's been issued. And so I guess what I'm having trouble with is whether we do it by CD, whether we do it by some sort of access, or we do it through research. Philosophically, I don't see the difference, other than the medium or the process is being used to make the access available. In fact, I would much rather have the access through research, because then we can track who's getting it. I mean, with the way things work in many counties, a runner comes by, gets whatever the medium is that their thumb drive or whatever, picks up the case types, and it's not just restricted to Class Cs in many places. That's just how they accommodate that. That's easier for them, and that's fine. But I'd much rather see it in research, and in fact, I'm speaking for the committee, but my personal preference is if you can walk up to the counter and get it, you should be able to get it through research.
And I think my concern is probably Courthouse News and some of these other sorts of organizations, that's precisely the argument that they, you know, that this stuff is available, we want it available now, you have it electronically, you could produce it. So, I mean.
Well, and that doesn't mean that we don't need to, before we implement something like that, layout, you have to be integrated.
Well, exactly.
And take care of, and take care of the timing delays
Right.
for warrants. In fact, for felonies, we've already got, what, a 30-day, 45-day delay
For indictments.
for indictment
For indictments, it's forever until he's arrested.
until they're arrested.
Or bond.
Yeah,
So we would have to incorporate
right.
all of those kinds of things. But I guess what our committee needs to know,
I
get a
think-
sense from JCIT, is we have the documents that I mentioned that everybody
Right.
said, that's a go right now, that's fine. But whether we do that today or we do that at some point in the future, the question is the broader issue.
Right.
What do we want to do around access? Because
So are you recommending then the piecemeal kind of deal where we do these larger set of documents just to get part of criminal going? Is that kind of your recommendation?
well, what we were thinking is if we got the information and indictment, judgment, sentence, and order of dismissal. If you look at what's already available, albeit from different sources, like all the bonding information is now available from a new site that OCA has put up in its public information. You would at least know what happened to the case. You know it was filed. You would know when it was disposed and how it was disposed. And at least to that extent, you have a picture of what happened in the case.
Mhm.
And everyone on the committee agreed with that.
Okay.
But that doesn't negate this other issue, which is how we grant access.
So, yeah, and so we did the hard work of creating that matrix and going down by case type and did it, you know, case type by case type, bit by bit, and did the hard work of, can we justify excluding this from view? Okay. Is there a reason why we don't use that process to lay out that matrix of all the things you could get and then go down it? I would also be interested in knowing, so we have Harris County that probably does most all those documents that are generally publicly available or probably publicly available. I'd love to know what other counties make all of their documents. John Warren, what documents are, oh, well, you're in county, never mind.
Patty's on there.
Oh, is Patty on there? Okay, Patty, what documents are available, currently?
Our criminal cases online, our documents are online available to the attorneys of record and the parties. As far as the public, they're available if they register on portal, and they're available if they're not sensitive, secured, sealed, that kind of thing.
Okay.
And so Patty, to register, you just need a name and an email address, right?
Correct. But
So you just make an account.
Yeah, so that would be the same that they would be doing right on Research Texas. It
Yep.
would have their name and whatever. So, okay.
the only
That's good.
difference is on, if we have documents that have sensitive information, obviously there's no sensitive data.
Right, and it shouldn't be available under our general overarching rule of
Right.
Research Texas that things with sensitive data that are marked don't get distributed.
We don't have sensitive data being marked in criminal. So if we
Okay.
have sensitive data, we would just mark it as secured in our case management system, and it wouldn't
I see.
appear on
Okay,
research.
I see. So in criminal law, people don't mark sensitive data, which, okay, that helps.
John, you have your hand raised?
Yeah.
Yes, sir. And I'm actually responding to Victor's message in the chat. He says, did the committee look at CJIS policies regarding criminal documents? When it comes, and that's, I think we actually need to have that discussion because there's CJIS information that should not be part of court records. The CJIS information is information specific to a defendant, and that would be like the information that's in arrest and in a arrest report and all those things. In some instances, people will attach those to a court document. So I think we actually need to have the discussion regarding Victor's comment as it relates to what people should be attaching to a document or should not be attaching to a document. And particularly if we're gonna start moving those criminal court records, quote unquote, to Research Texas.
John, I think there's a distinction in the CJIS policy between a criminal history record, which has all kinds of restrictions around it.
That is generated generally by a law enforcement
Right.
entity in the executive branch.
I don't know anything in the CJIS policies that relate to a court document per se.
No, and Bob, that's what I was saying. People will attach those documents to a document that they're filing with the court.
Yeah,
Well, then
well, then it's sensitive, that's what I would say.
Well,
they shouldn't be doing it.
I was gonna say, I think that's
Right.
against CJIS policy
Yeah.
to do that.
That's a violation of CJIS problem. CJIS policies regardless of the access. Because the first principle of CJIS access is you can access it and print it for the purposes of that particular point in time, and then it is destroyed because of how quickly they change.
And, I agree with you, but that's part of the discussions that needs to happen at judicial training, where judges admonish attorneys for doing that, and probably at CLE training for attorneys that's saying that you shouldn't do that. But we certainly get it.
Interesting, okay, yeah.
I'm not quite sure if Tracy or Patty, if you all get that information and your counties as well.
Our DAs have their own portal and they keep that information on their side. We don't see it. At all.
Same with Ms. Tracy.
Okay.
Yeah.
Okay.
Yeah.
All right, so going back to kind of the original kind of question I had, which is, would it behoove us, I mean, I think this is a great start on the criminal side. I think the committee worked long and hard. It had made some recommendations regarding these, 3 or 4 items that look good. But I wonder if we ought to just kind of go create a matrix, go down the list, and that way kind of make sure that we've addressed all the potential documents that'll be filed and decide yay or nay, on them. Is that a possibility?
Oh, certainly it's a possibility. I think, what we have to do though is identify, like we did before, in criminal, we have statutory restrictions already existing.
Right.
Where when we did the civil and the family and those others, we had a couple, but we didn't have near what we have in criminal that's already in statute.
I have a
Right.
question.
Didn't you say somebody had already looked at that, or somebody had some sort of
That was on the civil
resource?
side, and that was Sherry on the civil side.
Oh, on the civil side, okay,
Yeah.
all right, yeah.
So,
And Mark, you had a question?
Yes, sir. Was there any discussion in committee on the distinction perhaps between records of people when they're presumed innocent as opposed to once they're presumed guilty, like judgments versus indictments? Because it seems like that there's a real difference there. And if we're widening the fire hose in the ability to get records, I have seen really bad behavior recently about some of these attachments that John mentioned, where people in civil cases are getting these cases and then attaching them to civil filings and then e-filing. So now you have a document like an indictment, for example, that is now going to get pushed up to Research Texas and is accessible to almost anyone, as well as all the judges that might see it when it hasn't been properly admitted, foundation has not been laid, and there's still a presumption of innocence. So
And
it's
Mark, that's newspapers get that stuff all the time. They live
Right.
off of it. They go in and grab all that stuff and
I understand.
publicize it.
I understand, but I still think there's a difference between all or nothing thought. In other words, I don't think newspapers go and collect everything on everybody and put it out there. I think that there's a difference between public figures and non-public figures. And what we're doing
I
is
don't think, go
we're
ahead. I mean, I just think you're right as a citizen to go get all of that stuff.
right.
If
But
that's public.
Mark, in smaller communities, their local newspaper prints
Yeah.
all of the actions of the grand jury, everything that occurred in court.
Yep.
It's a standard feature on every pick a day of the week.
I understand. I just think that dissemination of information on the internet is much broader than in a local paper in a rural county.
Well, but this is like Research Texas, so people need to be registered for it. So it's not a, some big, bot that's collecting all this stuff. It's actually an individual, that's,
Well,
Getting it.
I can tell you, we've had bots, even with our login.
no, I
Yeah,
agree.
they create bots to create logins, to
Yeah.
go and search everything.
Right.
I've had to cut off IPs because they would just create 100 users and try to go to town on what they were looking for. And I mean, it's just, there's AI out there and they will be able to mimic a human.
So true.
So no matter what you do, you're gonna get it.
Yeah, so true.
So.
Let me jump in. I think it's been a good discussion, but I'm like Rebecca in that I just don't think that this committee or that I should be in a position of where the legislature has said something is open to be saying, yeah, but we still think there's some sensitive parts here. And so we're going to hold it off, with the exception of the timing for release, for security reasons, for the ability of law enforcement and the criminal justice system to effectively work. Other than that, I'm of a mind that if it's open, notwithstanding the fact that we're in an age of the internet where once it's out, it's out. I'm familiar with, long ago with indictments and with cases that were expunged, but the newspaper had already gotten the information, and you just go back and you can find the basic information that David Escamilla was was indicted, even though I wasn't convicted and got it expunged. It's just the way it is. And I don't think this committee, that's really the charge of this committee. So I'd like to be on that committee if we go that route. But my feeling is if it's public and you can get it in a district clerk or county clerk's office, then you should be able to get it on the internet.
Okay, so this has been a really, really good discussion. So what do you think your committee's next step, Bob? What would you like to do? I mean, I think a lot of people are interested and we've got some, some interesting questions to answer, but what do you think you all will need to do or want to do?
Well, I think there's, what does JCIT want to do
Yeah,
about the recommendation regarding those limited number of documents? Are they, do we say they're available or not? Or defer all of that to coming back with a complete package in which we do look at specifically what is restricted by statute and build a matrix off of that. So that everybody knows what those statutes provide. And then the time sensitive.
Would the statutes affect the categories of documents that have been suggested, like the indictment, judgment, and sentence?
No.
Okay, so the question is, I mean, that's a large group that would get started on criminal, so that might be beneficial to the public to have that to start with as we go and do a more detailed analysis of the other pieces that we want to take a look at.
Well, it gives you the beginning and the end of the criminal case.
Yeah.
You know what was charged and what happened to that charge. And that was the basic rationale committee.
Okay.
You'd at least have that.
All right, so could anybody want to chime in on this, on basically dealing with indictments, judgments, and sentences, just basically as information that the committee has recommended that we go ahead and recommend that be, and go ahead and place that, make that available on Research Texas.
Let me ask you, with the exception of only those counties that are integrated, is it because the other counties cannot be able to do this, or we're worried that they can't have the time to get to this and find sensitive documents? What's the reason for non-integrated not to be included?
Levels of security.
In other words, David, I think that on the civil side, we can rely on, or by rule, we rely on the attorneys to be able to identify documents that may have sensitive data as that's been defined. And as I understand it in criminal law, people don't put that in the indictment, that sensitive data.
They don't, but if an indictment is public and if information is public, and I can't think of what would be included in the indictment or the information that would require a clerk or someone to go back through later and say, well, we can't release this because of sensitive data. And then certainly for a judgment, what's going to be in a judgment that's sensitive, other than the timing, the timing of release.
Right.
This is Patty Henry, Chambers
Yes.
County. As far as David is correct. As far as the charges and / indictments, the judgments, there isn't any sensitive data on there that needs to be restricted. It's all the guts of the case that we have to be careful of.
Okay, all right. So indictment, judgments, and then the
Yeah,
sentence.
information's in indictments. So
Yeah,
you gotta pick
information.
You gotta pick up the A's and B's.
Okay. So my thought is that those are valuable to attorneys. We're not ready to do that outside of the integrated counties at this point in time. I guess that's a future, I would ask the committee to definitely delve into that and see, if we can expand that. But what do people think about doing this just for the integrated counties and going ahead and making this available on research? Do I hear a motion or anything? Do you want to do a motion, Bob, on that? From your
Yeah.
committee?
Yeah, I move to begin the process of getting criminal documents in Research Texas. We begin with informations, indictments, judgment, sentence, and orders of dismissal for counties that are integrated with Research Texas. And that we observe some timing delays where appropriate for protection of law enforcement and the process and the operation of the criminal justice system. And we will continue to look at expanding it beyond that when appropriate.
Okay,
Is there,
so this is a recommendation.
right. And
Okay.
so Judge Ferguson, you had your hand raised. You have a quick issue.
Yeah, keep in mind, and the clerks all know this already, but indictments are not public until they're served on the defendant. And so they cannot follow the same path that other filings follow, or we're going to have all kinds of problems. So there has to be some safeguard put in place to make sure nothing gets public until it is somehow authorized by someone ready to go.
That already exists.
Okay.
Cynthia, you had your hand up too?
I was going to say the same thing.
Okay.
Okay, so, so this is then, basically, I think that based on what everybody's kind of comments, is that the committee needs to write up what its recommendation is, right? With the idea that this is the direction we want you to go, to write up the recommendation that we can then circulate and then get everybody to vote. We can get them to vote electronically. And then pass it. I just want to make sure we all see something in writing and we know what we're approving, and then we can forward it
That's
on.
not a problem.
Yeah.
We just need direction.
Yeah, so this is the direction I think that this committee basically looks like they've given you. So that's number one on your task list. Number two is, let's consider the broader question of what else and how we're going to determine what else. I think that you're probably going to need a matrix, just like on the civil side, and we're going to have to do the hard work of finding those statutes that will prohibit that kind of information or what we're going to do. And so I would ask your committee to start looking more in detail to what all this other information is that needs to be looked at. And then we can also address maybe what is the difference between, and I've heard of integrated courts. We're going to have them all integrated, or for the most part integrated relatively, overall soon. So.
Well, that should be the goal, and one of
Yeah.
the reasons for starting with the integrated counties is Judge Ferguson, the point that he just made about withholding of indictments until there's been an arrest. Integrated counties, it wouldn't get up there unless the clerks had made that determination or verification, as opposed to a clerk's office that's in a non-integrated county.
Okay, yeah, that makes sense. Well, and this will be a good thing so that when, as courts come on, we'll have the matrix, we'll have everything ready for to accept the criminal filings that we deem appropriate.
Well, and I would anticipate, like we did with civil, we're gonna have to have a couple of working groups, working sessions,
Oh, yeah.
and maybe groups to go through all this, and gonna need Cynthia and Casey's probably one of the lawyers and OCA staff to help us go through this.
Okay.
Just like we came up with the standards on case types.
Yes.
filing codes, we're gonna have to come up with these document codes that meet these documents that are going to be shown on Research Texas so that Tyler knows what documents to show to the public and whatnot.
Yeah.
Because every CMS, I'm sure, will identify those documents that we're saying to make available different. So we'll have to come up with a code that then Tyler can use to be able to know these are the documents I have shown to the public.
Yeah, no, that's true. Yeah, it's, I mean, it's hard work, but I think it's necessary in the criminal side for sure.
Right.
Okay, we need to probably look at, I think you had one more thing under the standards committee, Bob, and that had to do with visiting judges. Do you want to, is Dan Hine on the,
No, Judge Hines,
Judge Hine's not on
and
there?
then Justice Dawes raised his hand.
Okay, Justice Dawes.
As to the previous motion, are we tabling that motion to discuss it at a later date? We probably need some sort of resolution on what we're doing on what's pending right now.
So I thought that more or less there was a consensus that we would start with the information, indictment, judgment and sentence in terms of writing up a recommendation that those actually be permitted to go on to Research Texas. And that's kind of what I thought the consensus of the committee was after discussion. But if we want to vote on that, that's fine.
Whatever's fine.
Okay, so the issue before the committee then is whether we should move forward with just this limited amount to go online from the courts that are integrated, or do we wait until we have a matrix and do it all together at some later date?
And I think Bob's motion on the table is to do those 4 document types now.
Now.
And so I guess the question then is, do we hear a second on Bob's motion? And if so, then we can vote or table it or whatever we need to do.
Judge Ferguson had an issue.
Judge Ferguson?
Are you okay, Judge Ferguson?
Well, I'm not exactly sure. I'm a little hesitant from what I've heard to say go. But if we're talking about constructing a recommendation, I have no problem with that because that means further discussion.
Yeah,
If that's
it's a
the motion.
recommendation which we'd have to vote on. So that's all this is you can kind of move forward to make a recommendation that we'll all look at and vote on before it would ever be submitted.
I can't imagine anybody being opposed to that. So sure, great. Let's keep moving.
But
I'm
we're
in
not
favor.
we're not talking about doing anything as of May 17th that we're suddenly putting this information online or anything like that.
No.
That's correct.
I think I would have to oppose the recommendation just because the inclusion of informations and indictments, given that the effect of this is to really increase widespread dissemination. And so for whatever it's worth, 2 cents.
Okay. All right, so let's go ahead and have a vote. All in favor of just moving forward to draft a recommendation that the committee will consider. If you'll raise your hand and say aye.
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 Can you take a look? Okay, all against? Mark, that's you.
Yes.
Okay.
Opposed.
Okay. All right, then the ayes have it. So we're going to ask the committee to go ahead and make a more detailed recommendation that we can actually look at and kind of assess and determine and have further discussion then about whether to proceed with that recommendation or not. And we can do some of this online. The recommendation will be circulated online. And then if we need to have schedule a meeting, a Zoom meeting where we discuss it further, we'll do that. All right.
Justice Simmons, this is Laura. Do we have a deadline for that?
No, I don't think so, other than there are tons of lawyers and people out there that have been wanting criminal cases for years. That's the only thing. So there's no specific deadline. What I'd like to do is get the recommendation from the committee. Bob, how much time do you think you need to draft that?
We can get it drafted next week, circulated amongst the committee. Once committees, we're looking end of May, first week of June.
Okay, so maybe what we do is, let's see if we can get a recommendation going and plan on circulating it by the 31st. That gives you 2 full weeks, or would you rather do it on the, on June 3rd, which is a Monday, or the 4th, which is a Tuesday? What's your committee? I don't know what everybody's plans are for
Tracy?
Memorial
But I
Day.
think with the holiday week coming
Yeah.
up, we probably need the extra week.
Okay, then do you want to wait and get another week and do it on the 7th and submit something by the 7th of June?
Yeah.
Yes.
Okay, all right, let's put June 7th as the date that we, get the recommendation from the committee. All right, okay, so that closes out now the criminal law discussion. Now there's a visiting judge access discussion. And that was something submitted by Judge Hine. Now, I hate to should we take this up if he's not here? Do you feel comfortable with it, Bob? or-
No,
Okay, defer.
I defer.
Okay, all right. So we're going to defer the discussion on the visiting judge access to research until we can have Judge Hine present to discuss a proposal that he's recommending. All right, so, old business. We had sent a recommendation to the Supreme Court regarding orders. I think they're kind of looked at it. Does anybody have any insight?
I know Justice Boyd's on it.
Justice Boyd.
He may have some insight. All I know,
Where we are,
all I know is
just
that
reviewing.
my understanding, or the only updates that I have is that the JCIT did submit them. I know that
Yeah.
the court has received
Okay.
them. And to my knowledge, the court hasn't issued any kind of order, so I'm assuming they're still deliberating or doing whatever it is the Supreme Court does with those things.
Well, this week it's been exchanging emails, so deliberating in a sense, and we're close. We're very close.
Good,
Excellent.
good. All right, does anybody have any other old business that they want to bring up? All right, then with that in mind, we will go ahead and adjourn this meeting. And thank you so much for your time, and be looking forward to getting a copy of the recommendation on the from the criminal committee. And thank you, criminal committee, for all your hard work.
Next meeting.
Our next meeting has not yet been set.
Right, so we are concluding our, basically, we usually meet, this would normally have been our last meeting in the year. And so, we will, be setting up the new meetings, probably in June, and send those out for the following year. So, anyway, have a great Memorial weekend, and we will be in touch as far as the criminal. Okay, take care.
Thanks, everybody.